Okay, no, Honourable Minister. Honourable Minister, please.
Sir, a very large number of honourable members have participated in the discussion which Shri Nachiappan initiated. First of all, before I give the whole scheme of the Act, because I said I'll speak towards the end, I must join issue while clarifying the queries raised with at least the impression which one of the honourable members who spoke gave. Because the impression given was that there is only one person in this country who is fighting against black money. And a reference was made to cooperation with the Germans, that neither the earlier government nor the present government was interested in getting any cooperation from the Germans. So at the very outset, the record must be set straight. Germany gave us the information when the UPA government was in power in 2009 that there were accounts of some Indians at Liechtenstein, the information which the Germans had got. Efforts have been made over all these years, which have now culminated, and these were 26 entities, 6 of whom were found to be non-resident Indians. So as far as NRIs are concerned, they are not residents within the meaning of Section 6 of the Income Tax Act, and therefore they were not within our jurisdiction, or at least the revenue jurisdiction. With regard to all others, assessment proceedings have been completed, tax and penalty demands have been raised, and criminal prosecutions in regard to each one of them with evidence enclosed has been filed in courts. Whether over and above this the Germans had some other information, as the honourable member had claimed, we wrote to the German authorities and who said, sorry, over and above what you have, we have no other information. With regard to the second set of information which had come via France, there was originally names in the HSBC account of Geneva of 628 persons. Now some names were very generic, so it was difficult to identify them. 422 of them have been traced. The peak balances in each one of those accounts has been found out. Assessment proceedings in most cases have been completed. A tax demand of 4,520 crores along with penalty has been levied against them. 121 prosecutions have already been filed. And therefore, governments have their own methodology of working, the revenue departments have their own methodology of working. Neither any one of us nor they can claim that we are the only ones fighting black money and then fall in love with ourselves for doing so. But in each one of these cases, whatever steps had to be taken have been taken. Sir, what is the overall scheme? Some members said, stop generation of black money in India. How do you get information from outside the country? Now, these are Indian entities who have illegal funds abroad. Illegal funds abroad could result only out of tax evasion. You evade tax and you keep your money outside. Or these can also be monies earned out of crime. Crime can be corruption, crime can be narcotics, crime can be terrorism, crime can be anything. Originally, the impression was, and that was the position in law, once you cross the territorial boundaries of a country, it was very difficult to catch evidence outside the country. So a scheme used to be developed where you used to seek mutual cooperation through letter rogatories and others. It was a slow process. most tax havens had worked on a principle that if it is money coming out of tax evasion, we will not cooperate. People across the world are entitled to evade taxes and keep monies in our countries. Their economies were functioning on that basis. But if it is crime money, profits of crime, and that crime on the principle of dual criminality is a crime in both the countries, then we will cooperate. This was the position 20-25 years ago. Thereafter came a second stage where countries started entering into mutual arrangements with each other for cooperation, double taxation avoidance treaties and so on. Now in all these treaties, there used to be a clause that till such time you are charging a person in court, you will not make a public disclosure. This was the secrecy clause, and the reason was that those countries and their banking systems owed some confidentiality to their client. So unless investigations proved that this was illegal money, we cannot name him, we cannot shame him. For instance, in Liechtenstein alone, we have found several names to be NRIs. Similarly, in HSBC, some names have been found to be NRIs. So an NRI who legitimately has income outside can keep it there. We can't name him and start dubbing him as a criminal. So a suggestion which was just now made, that Indian Parliament must get a jurisdiction to legislate beyond its territorial jurisdiction, that monies lying in other countries now belong to India, and those other countries will automatically accept our law, transfer those monies. They will not even determine whether those are legal funds or illegal funds. They will not go by mutual cooperation treaties. Now, these are fanciful ideas which in any form of enthusiasm or demagoguery may sound very attractive, but to legally sustain them is not so easy. Therefore, the second stage was that we were trying to cooperate. Now, in the process of cooperation, what happened was, the courts passed orders, and there was a debate, make these names public. Now, we had taken a position, we can only make them public once prosecutions are filed in court. Now, the court said, give the names to some people, and those people made them public. I have now with me letters from France and in Britain which say, please explain how the names which we have given you have landed up in the Indian newspapers. Because the moment you make it public, you are violating those treaties. You can only make them public once you hold a person to be prima facie culpable and file a prosecution in court. Till then, their confidentiality clauses come in. So this enthusiasm and crusade actually becomes a liability, because once other countries stop cooperating with us, the effect will be we will get no evidence. And once we get no evidence, the account holders will say, you have failed to prove a case against me. Now we are reaching, sir, the third stage. And the third stage is, and this is the most important limb of our entire scheme, the G20 has taken an initiative, India is an active participant, that when Indian citizens and residents in India transact in foreign currency abroad, so I stand corrected, the letters are from Germany and UK, I said France by mistake. When Indian residents abroad transact in some money, there will be an automatic exchange of information provided to India. It will come to us in real time. Now, G20 has taken this initiative. That is the first step. Other countries are also following with this initiative. The second important initiative which has taken place is that the Americans have brought a domestic law called FATCA. FATCA is the short acronym, where every country who deals with America must have an agreement entered into. And that agreement must provide for this automatic exchange of information. of transactions of citizens between the two countries. So all American citizens in India, Indian citizens in America, the moment they transact in any currency, legally or illegally, there is an automatic exchange of information. Now, along with this automatic exchange of information, other countries which enter into this arrangement with US, in the next stage will have this agreement between themselves also. And the penalty is that those countries which don't enter into this arrangement, there will be a sizable withholding tax on all remittances to those countries. So your export earnings, your NRIs sending you money will all come down. So we are also becoming a party to FATCA. And this entire phase is going to be completed by 2017. So we are now, the world is now entering a challenging phase where there will be real-time automatic exchange of information of foreign currency transactions. So we will have an opportunity, then we don't have to run to Germany or France, we'll start getting the information in real time. That is step one. As far as domestic generation is concerned, we really have to develop a will in this country as to how do we curtail the use of domestic black money in all sectors where there is black money which is prevalent. There are several steps in the finance bill also which I have indicated, which we are trying to squeeze the size of black money as far as domestic transactions is concerned. Squeezing the size of that black money will help us. It increases our taxes, revenues, it increases our GDP. It also enables the government to lower the rates of taxes if you have more volumes of taxes with you. But then some of these steps are not necessarily very popular steps. So in phases, we have to take those steps and squeeze the quantum of black money. The third stage is what we have done in this law, and the scheme of this law is extremely simple. This law does not deal with domestic black money at all. It's a law which only deals with undisclosed foreign assets and incomes outside the country, which in the Lok Sabha, the name has been changed, the word black money has been added because people understand that phrase more easily. Now, so far this black money outside the country is unknown and people don't pay taxes, they generate that income or asset and keep it outside the country. The scheme of the law is extremely simple, that if you have any income or asset outside the country, this is now going to be taxed in India. So for the first time, a tax is being imposed on that undisclosed income. This tax, since it is being, for the first time it is being put on that income, a compliance opportunity is to be given. So we will have a compliance opportunity which will last a couple of months. You make a disclosure in first stage. The period for that will be prescribed in the rules. After you make a disclosure, since you have kept it illegally, you pay 30% tax and 30% penalty. Once the compliance window closes, which again may be a few months, in that event, the law becomes further operative that you will be charged 30% tax. There you don't have to make a disclosure. Azad Sahab was saying, then do you have to make it? No, you don't have to make a disclosure. Disclosure is only during the compliance period. In the second phase, you pay 30% as tax and you will pay 90% as penalty. 300%, which means 30 plus 90, which is 120%, which means the value of the asset is actually gone. Now, if the asset is outside India, how does your jurisdiction enter there? So we have simultaneously amended in the finance bill, one of those 5 bills which we have amended, which my friend Jairam was referring to, was the money laundering bill. And in the Money Laundering Act, the amendment that we have made is that for that recovery, your assets of an equal value in India can also be attached. That is the amendment to the PMLA that we have made in the finance bill. So within the compliance period, you pay 30 plus 30. Once the compliance window closes, you will pay 30, you will be levied a tax of 30 plus 90 plus prosecution, where minimum sentence is 3 years and it can go up to 10 years. So the strict provisions will start once the compliance window closes. The compliance window has been given because it's a new tax, therefore there is an opportunity to pay the tax which is being given to you. Is this, members wanted to know various questions. Why the United Nations Convention Against Corruption operates in a slightly different area. You may have assets outside which emanate out of corruption, they may emanate out of crime, or they may emanate only out of tax evasion. We are not in this law dealing only with corruption. Supposing there is a case where somebody by under-invoicing or by over-invoicing keeps money outside the country, or he evades local taxes here and by hawala takes the money outside. So this would not be covered under the UNCAC, but it is still going to be an offense as far as this section is concerned, this act is concerned. Now a question has arisen, is it an amnesty scheme? It is not an amnesty scheme. In an amnesty scheme, you pay your taxes and go home. Here, even during the compliance window, and I may tell you the problem with amnesty schemes, the 1997 scheme of the United Front government was challenged before the Supreme Court. And it was challenged on the ground that you are creating two categories of assessees. The honest man and not the honest assessee. And now you are bringing a scheme in order to favor the person who's not clean in paying his taxes. At that stage, the government had filed some affidavit, the United Front government had filed an affidavit before the Supreme Court which indicated this is the last scheme. And therefore, these schemes are vulnerable to challenges of this kind, particularly because of that affidavit also which was filed. Now, this is not an amnesty scheme, so there is no waiver of any tax. On the contrary, it is 30 plus 30, 30 plus 90 plus prosecution. Amnesty schemes also have a protection against naming and shaming, that your identity will be kept a secret. There is no such protection which has been granted. The third effect of this has been that when you come out with an amnesty scheme, superficially you think you've collected some money. But the 97 experience was, you did collect some 10,000 crores odd, but then the next 2 years collection saw a corresponding dip. Because the amount of money supply within the system itself doesn't immediately expand. So this is a compliance window where you are giving an opportunity, and once the compliance window closes, you are going to be taxed very heavily. This is the entire scheme as far as taxes are concerned. Now there are two concerns, there is one or two concerns which have been expressed, and one is a legitimate concern. Are innocents going to be harassed as a result of this? The answer is no. First of all, it doesn't deal with domestic tax evasion at all. The Income Tax Act will deal with it. Secondly, I have put in this section, I've been careful enough to put a clause there, that there are students who go there to study. When they come back, there is some amount lying in their bank accounts which they open, which they have forgotten to close down. Will they be liable? The answer is no. So in order to be actionable, the quantum of money has to be more than 5 lakhs. That's a specific provision in the Act itself I have already provided, because the idea is not to chase small people who may just out of carelessness have left their account not closed or left their account open when they left with a few $100s in it. The idea is not to chase those people. Secondly, as far as the the application of this act is concerned, it clearly says in section 2, it applies to resident taxpayers. And therefore, all Indian professionals working abroad, etc. And resident taxpayers as defined are those who are liable for assessment under the Income Tax Act, section 6. And those are people who spend more than 182 days in India. So those people are not going to be covered. So those who work abroad are not going to be covered. It is those who are resident taxpayers as far as India is concerned and assessees in India who keep income unauthorizedly outside who are going to be liable under this act. Now, one of the further changes which has been made, and that's why it's not an amnesty scheme, is that normal violations under Income Tax Act will be dealt with only under Income Tax Act. But if it is a violation of keeping a national asset outside the country, then we have made it now a predicate offense which is liable for action under PMLA also. And that is what leads to attachment of equal amount of assets as far as India is concerned. So this is not an amnesty scheme. It's a taxation which is being imposed on an asset or an income outside. Since the tax is being imposed for the first time, we are giving you a compliance period where you pay 30 plus 30 and then you can sleep well. And then also remember, if you don't use this compliance window now, time will run out because by 2017, there will be a real-time automatic disclosure of information taking place. The world is no longer willing to tolerate tax havens which thrive in secrecy. And therefore, with this period now slowly approaching, it will be safer for people to follow the legally correct rule rather than take a risk and then have sleepless nights at all. This, Mr. Deputy Chairman, in short is the scheme of this act, of this bill. I commend the bill for consideration and return to the Lok Sabha.
अरे क्या बात चिल्लाते क्यों है
एक क्लैरिफिकेशन माननीय वित्त मंत्री जी, माननीय वित्त मंत्री जी इतना आप बता दें, आप ये बिल लाए हैं, ठीक है हम लोग मानते हैं काला धन नहीं ला सकते, बिल ले आए हैं, लेकिन क्या गारंटी है कि जो 30% टैक्स देगा और उसके बाद 30% पेनाल्टी देगा आपके रजिस्टर करने के बाद, अगर कोई पीआईएल में सुप्रीम कोर्ट चला गया तो क्या वो सुप्रीम कोर्ट उसको उस पर जांच बैठाल सकेगी? उसका कोई ऐसा आपने प्रोटेक्शन किया या बता दीजिए। एसआईटी है, कोर्ट है, जैसे आज कोर्ट ने आदेश कर दिया 3 फोटो लगेंगी, आज जैसे आदेश कर दिया 3 फोटो लगेगी, उस पे आप क्या कहें? अगर नई प्रोटेक्शन है तो कोई क्यों रजिस्टर्ड करेगा?
बोलिए बोलिए बोलिए।
मैं माननीय मंत्री फाइनेंस मिनिस्टर साहब से एक क्लैरिफिकेशन चाहती हूँ। बड़े विद्वान हमारे टॉप के वो लॉयर हैं और उन्हें ये भी मालूम है कि इसमें कितनी पेचीदगियाँ हैं। अभी जो उन्होंने बताया हम लोग की समझ में आया। मैं सिर्फ एक क्लैरिफिकेशन चाहती हूँ कि उन्होंने जो लोकसभा से पहले भी उनको मालूम होगा कि ये पेचीदगियाँ हैं और कोई भी जिम्मेदार पॉलिटिकल पार्टी जब आवाम से चुनाव लड़ती है तो जो वादे करती है उनमें कुछ सच्चाई है। तो माननीय मंत्री जी को ये सब पहले से मालूम था कि ये सारी पेचीदगियाँ हैं। तो मैं ये जानना चाहती हूँ कि किस बेसिस पे आपने इस देश के अवाम को, मैं समझती हूँ कि एक तरह से गलत बयानी की कि आपने उनसे वादा किया विद इन 6 मंथ, आपको मालूम थी कि आप पेचीदगियाँ हैं और पूरी दुनिया के सामने एक मसला है ये ब्लैक मनी का। तो ऑन व्हाट बेसिस आपने चुनाव में इस देश के लोगों से वादा किया कि विद इन 6 मंथ हम काला धन वापस लाएंगे?
सवाल सीधा सा सवाल पूछना चाहता हूं। हम पूरा समर्थन दे रहे हैं, जैसा हमारे नेता ने कहा है, हम इस बिल को समर्थन दे रहे हैं। अब तो ईमानदारी के साथ आप खड़े होकर बता दीजिए जो अकाउंट हमारा खुला है उसमें कितने दिन में 15 लाख रुपए आ जाएगा, मुझे बता दें बस।
No, please, let me take.
Sir, I have a query. Sir, my
We have to,
clarification,
it is fine, it's already
my
time.
clarification is, I have a clarification, it's a serious. So far, the finance minister and his junior also in the finance, the Minister of State for Finance, have been telling us for the last 2 weeks that all their planning and financial planning has been done using a process of benchmarking. My question is very clear, is this bill which has been coming up today, which we are all getting together to pass, what is the benchmark of this 2-3 months from now to show that this is a good legislation in terms of money coming back? What is the benchmarking? The benchmarking.
Sir, I have a question.
Okay, that's okay. No. He is not reacting, so that's all. Not reacting. But
And
Minister,
clarification was before the House, whether he will respond or not, it is up to him and up to you. Will you permit?
yes.
My question,
No.
my simple
all.
clarification,
Three
Honorable
from
Finance
there.
Minister has very nicely elaborated the scheme. And from that elaboration, I understand this is basically a deterrent exercise, very effective deterrent exercise, I must say, and not an amnesty, but a clear compliance window. But what is the, how do you ensure that this will act as a gravitational force for bringing the black money abroad? Is it only that 2017 the clear opening of the all facts is going to happen, and by this deterrence exercise, all the black money will
Okay.
fly to country? Is that the perception
all right.
we want to
Now,
understand?
are you reacting? Yes. He is not responding. He is not responding, so no use. The question is that he is not responding. Sit down. The question is that the black money, undisclosed foreign income and asset, and imposition of tax bill 2015, as passed by Lok Sabha, be taken into consideration. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. The motion is adopted. We shall now take up close by close consideration of the bill. Clauses 2 to 88 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clauses 2 to 88 are adopted. Clause 1, the enacting formula and the title stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and the title are adopted. Sir Arun Jaitley to move that the bill be returned.
Sir, I move that the bill be returned.
Motion moved that the bill be returned. The question is that the bill be returned. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the